We've all heard the song, breaking up is hard to do. From what I see in family court, that is a huge understatement. Marriage breakdown can be painful and traumatic, especially if children are involved. Today on Family Matters, we'll discuss what you need to know about breaking up.
Separation and divorce are difficult. You have rights. We fight for them.
Why do people hire family lawyers? The most important reason is to protect their children. I'm John Schumann, the head of the family law group at Devery Smith Frank. Clients also want to protect themselves, protect their finances, and plan for their future. Contact me at 416-446-5847 or at www.devrylaw.ca. We will protect and guide you.
At the Watson Gopel Family Law Group, our focus is to work with our clients to keep costs, conflict, and emotional stress low while trying to achieve favorable legal results. Our lawyers are skilled in traditional family law litigation, but we pride ourselves on promoting innovative, out-of-court options such as mediation, arbitration, collaborative law, and parenting coordination. Your family law issues are unique, and our approach reflects that. Watson Gopel, contact us today.
Today we're talking about something that few couples ever want to contemplate. But when you look at the statistics out there, at least half of all couples will have to deal with it, breaking up. Even though there are huge emotional and financial consequences for everyone involved, most people are caught off guard and totally unprepared when it happens. Today's guests will be discussing what you need to know and do if you and your partner separate. Our first guest is family law lawyer Lorne MacLean. Lorne, welcome to the show.
Thanks. It's an honor to be here, Judge
I
Brownstone.
would imagine that you get a lot of people coming to you who have just separated.
Right. You get a lot of people that come in. Some of them are a little bit shell-shocked. We like to make sure that they understand at the beginning that they will get through this, that it will take some time. We understand that we're seeing them at a time when they're not at their best, and so we have a wealth of patience for them. We understand that these are not normal times for the people, but we like to reassure them.
But do you sometimes get people who come to you planning to break up? They know they're going to end the marriage, they just haven't told the partner yet.
Right, and in those cases we try to prepare a letter to the spouse that may be in shock or going to be in shock that is conciliatory in tone. We try to soften the impact of that because we want that person to recognize that the marriage is over, but we don't want them to be overly distressed, so it prevents us getting a fair settlement for both sides.
Because I think it's true to say, at least my experience is that when a couple comes to court, well, the ones I see, they're not at the same emotional state. One may have disengaged emotionally from the other long ago, and the other may be totally shocked, as you said, shell-shocked, that the relationship is over. So they're at these different emotional stages, and yet the one that's just in shock has to get up to speed, because now we're talking about selling the house, who's going to have the children. How do you deal with that as a lawyer if you've got somebody who hasn't even absorbed that the marriage is over?
We will walk them through the steps as to how it's going to be resolved. We will tell them not to panic. We will tell them, for example, there is no shame or embarrassment in going to a counselor to help them get through this. What we don't want is sometimes you'll get a very toxic client on the other side that wants to continue the relationship by having sort of prolonged litigation. It's a negative relationship, but it's still a relationship. And you don't want to trigger that type of relationship where they use the court to try to force that spouse to not be able to move on with their lives.
Do you sometimes refer your clients to counseling?
Yes, we'll send them to counselors because as lawyers, we're sympathetic, but our skill set is trying to get a fair resolution promptly, and if we can't do that by negotiation, our job is to go to court and to argue, ferociously, some people say, on behalf of our clients, but at the same time, objectively.
What do you need to know and what do you need to do if you're going to break up?
All right, well, what I like my clients to do, I have a planning for divorce checklist that I have on our firm's website. You should go through the mail. What you want to know whether you're breaking up as the initiating spouse or the spouse that's in shock is knowledge is power.
Well, what do you mean go through the mail?
Well, you want to make sure you know where all the bank accounts are, the family business, know about as much about the family business as you can, RSPs, a gold mine to try to find out what someone really earns is a loan application, for example. It's no surprise.
So you should go snooping.
Well, many of these accounts are going to be joint. So I'm not saying that you're going to open mail, which may in fact be illegal in many jurisdictions, but you are certainly allowed to look at the family finances. And if there's been a history of you being able to look at those documents, it's probably not an issue. But again, consult a lawyer in your jurisdiction.
So you need to do a little bit of detective work if you think that you're going to be breaking up and find out what the other spouse has.
Right. You want to make photocopies of all of these documents and put them in a safe place outside of the family home. You may wish to redirect your mail to a new location outside of the family home so they're not seeing letters from the lawyer. You may want to change your password on the computer, for example. But we want to empower clients. We want the clients to be child-focused. And getting sort of a head start by knowing what all the finances are is huge. Being active in your child's life, knowing all the teachers' names and the coaches' names. Nothing more embarrassing for a father on the stand for cross-examination to not be able to name little Johnny's teacher or Sally's piano teacher. And you might want example, for example, I've used Father's Day cards or Mother's Day cards that say what a great dad or great mom you are when the other spouse is telling the court what a terrible parent you were. Those things are golden.
Although it seems kind of sad that if on the brink of breakup is the time that you should find out what your child's teacher's name is, maybe if you'd known before, your marriage wouldn't be ending.
Well, the point is,
I'm just saying.
It's not a litigation strategy to be involved in your child's life. It's a good thing.
Yeah.
So
I guess that's the point.
Yeah, exactly. And so if you haven't been as involved as you should, get involved. The child is the winner too, you see.
Absolutely. Now, you said that you will argue ferociously for your clients. I don't want people to get the impression that that's the only style that lawyers can have, because it seems to me that it's better for people to try to resolve it amicably.
It is better, and 3 to 5% of the cases actually go to court. And so
in all the rest of the cases, how do you convince a client that the proper thing to do is to try to resolve it peacefully?
Well, again, at the beginning, you want to be objective with your client. So it's no good for a lawyer to try to sugarcoat things for a client at that initial interview to try to get them hired, because that client's going to be dissatisfied at the end. We want to give them a reality check right off the bat. We want to say, here's the realistic range. We're going to try to get you at the high end of the realistic range. So,
well, that's a good start to our discussion. Thanks for being on the show, Lorne.
Thank you. We're
going to take a break. When we come back, we'll go in chambers with family law lawyer Kerri-Parslow. Stay with us.
Justice Brownstone's wardrobe is provided by D.G. Bremner & Company, a luxury sportswear retailer for men. Visit dgbremner.com.
Separation and divorce are difficult. You have rights. We fight for them.
Hello, I'm Michael James O'Connor. Family law requires sensitivity, flexibility, and confidentiality. The lawyers at McConn & Beon, O'Connor & Peterson are trained to use all avenues available, including alternative dispute resolution, mediation, and litigation. Our family lawyers are equipped to handle your needs in a sensitive and positive way. We can help. Please call.
We're in chambers with lawyer Kerri-Parslow. Kerri, thank you for being on the show.
Thank you for having me.
When a couple first breaks up, the very first thing that most people do is make an appointment with a lawyer. How do you find a family law lawyer, a good one?
Well, I would say talk to people that you trust in your community. A lot of people have been through legal issues of some sort throughout their lives, and so, that's always a good place to start.
So word of mouth is really the major way to be referred, and would you agree with me that you'd want a lawyer who specializes in family law?
Absolutely.
So let's assume that the lawyer has received a call from a client who wants to come and see you, and this is the very first appointment after they've broken up. What do you expect the client to bring to the appointment? How should that client prepare for that very first meeting with you?
Well, a lot of clients will show up with a detailed chronology of events. That's really helpful. That sets out a lot of what they think is really critical to their matter, and it also assists us in sort of probing further questions and finding out all the information that we need. If they're financial matters, bringing any financial documentation that might be critical. If they're in court, bring the court documents, obviously, so that we can take a look at those and figure out how we have to proceed.
Do you find that sometimes the person is so emotionally distraught that they may not really be absorbing what you're saying?
Yeah, that's often the case. And they'll ask you the same questions over and over again. So sometimes having, someone that they can leave and sort of discuss it with them, and they can reiterate the points that we made to them, that can be really helpful.
Well, I'm going to ask you the one question that every lawyer hates. How much money does this cost? How much money should a person expect to bring to that first interview as a retainer?
Right. So there's obviously a consultation fee, which you can typically find before you arrive, but the retainer fee can be anywhere from a few thousand to several $1,000s. It will depend on the seniority of the lawyer that you're retaining, the complexity of the matter at hand.
Why can't lawyers tell people how much it's going to cost?
Virtually everybody asks that question. And we appreciate that they want to know that. They want to know how to budget for this sort of thing. But it's impossible, virtually impossible for a lawyer to anticipate what the issues are going to be going forward, what the other side's position is going to be on the issues. Are there going to be new issues that come up as the matter progresses?
See, I think a lot of people don't get that. They don't realize that you don't know until you find out whether the other side is going to get a lawyer. Are they going to be disputing what you're claiming? Is there going to be a long battle over something like custody?
That's right. Or
property? They don't realize, and you're charging by the hour, so they just don't realize it. But it really is an issue. As you know, many, many people come to court without lawyers, and what they tell us judges is, I couldn't afford it.
And we'll often tell clients that, their approach to the file and how they're going to handle things is really critical. If you're going to be reasonable and child-focused, and you're going to be willing to make compromises and concessions, then it's probably going to cost you less money. But if you're going to be, if you're going to battle every issue with your spouse and refuse to do the things that you need to do with respect to producing disclosure and all those sorts of things, then it's going to be drawn out and expensive.
I think that's a really important point, that people understand that if you don't want this to be expensive, you have to provide all the information about what your income is, what your assets are, and be fair and be reasonable and be willing to compromise.
Absolutely. We have really onerous disclosure obligations in Ontario, but they're there for a reason.
In every jurisdiction.
In every jurisdiction.
Really everywhere in North America.
Yep.
It's expected that you're going to fess up to
Absolutely.
Everything that you have.
Yep.
And I'm often amazed as a judge that people complain that the legal system is so complex and it takes so long and the lawyers are so expensive, when many of them have not provided the information they needed to provide. And if they had, we would have done it much quicker.
Absolutely. They're often the reason.
So do lawyers tell this to their clients?
Absolutely. And
it's
repeatedly.
Nice to know.
Repeatedly. We follow up with clients, on a regular basis about these sorts of things, and we let them know that this is driving up the costs and those sorts of, that the retainers are going to have to be replenished for that reason. And sometimes that helps the clients, to move things forward and start doing things more quickly, and sometimes it doesn't.
Now, you mentioned about being child-focused. I'd just like to pick up on that, if I may. When you get a client that says to you, I'm the better parent, I want the children with me, the other parent is not a suitable parent, how do you begin to explain to your client what might or might not happen when it comes to custody?
Right. Invariably, almost every parent that walks in thinks that they're the better parent. And they're very critical of, their spouse's parenting abilities and decisions that they've made and those sorts of things. And so we point out very early on that, unless there's very extreme conduct from the spouse, that you have little issues with the way they handle time with their kids, or things that they do with their kids or don't do, or that they're taking them out for fast food or things like this. Those aren't serious enough issues to ever limit completely or
to terminate
contact with the parent.
So you explain to parents that they have to expect that they're going to be compromising and arriving at a parenting plan that's going to probably have the child spending maximum time with each parent.
That's right.
I wonder whether most parents understand that because they seem so angry with each other that they let those feelings get in the way of really what is often quite common sense. Yeah,
their vision gets very clouded. It's a very emotional time in their lives. They're often not able to see the issues, from somebody, who's behaving reasonably and see them through those, that type of approach. So,
I hope that by listening to this interview, more people will be more reasonable than they would have been if they hadn't. Thank you so much, Kerri.
Thank you.
Coming up after the break, we'll continue our discussion with lawyer Erin Crawford.
People often ask the family lawyers at Devery Smith Frank if we can protect their rights without going to court.
We know how to get people the results they want, through mediation, arbitration, or collaborative law, often without the stress and hostility.
Our full-service firm will protect you, your children, and your finances, in or out of court. Contact us at 416-446-5847 or online at www.devrylaw.ca.
Hello, I'm Michael James O'Connor. Family law requires sensitivity, flexibility, and confidentiality. The lawyers at McConn & Beon, O'Connor & Peterson are trained to use all avenues available, including alternative dispute resolution, mediation, and litigation. Our family lawyers are equipped to handle your needs in a sensitive and positive way. We can help. Please call.
We're back in chambers with my next guest, Erin Crawford. You've been a lawyer 10 years.
Yes, I have.
I want to ask you a question that I don't know how often it comes up. Do you get people that come into your office and say, I'm planning to break up with my spouse? They don't know yet, but I'm planning to leave them. What do I need to do?
Right. We get that quite frequently, actually, people coming in and trying to plan and get some information about what their rights will be, what their responsibilities will be, and to get some information about how they can best prepare for an upcoming separation when the other spouse doesn't know.
Do you ever feel like this is a bit weird that they've got a spouse at home who has no clue that they're about to leave them?
Sure. I mean, you feel for the other spouse who has no idea that this is coming, but we look at it from the perspective of preparing the client for, what's to come for them, and our obligation is to the client. So it's actually helpful if we have clients that come to us that are somewhat prepared.
So what if they say to you, let's say a typical situation, we own a home, it's jointly owned, matrimonial home, there's a cottage up north somewhere, we've got some investments, some joint bank accounts. What do you say?
Well, I mean, we try to encourage people not to clean out bank accounts and take off for the south. The financial disclosure requirements make it so that everybody has to put all of their assets and all of the information on the table.
That's a really important point, isn't
Absolutely.
it? I don't want anybody to miss that.
Right.
You have to disclose everything you've got.
That's right. So wherever it is.
So you can't put it in your girlfriend's name,
no.
Transfer it to your parents,
no.
Hide it somewhere.
We're pretty good at tracking information and tracking money, so people that think that they can just send their money to their offshore accounts or try and get it out of their spouse's reach, it's really difficult to do that.
So let's say this person has a spouse at home who's a stay-at-home parent, no income. So this client of yours has been paying the mortgage, all the utilities, all the bills, but they're going to move out.
Well, usually, I mean, unless you want to get yourself into court right away, which is what we're trying to discourage, we're hoping that people can try and negotiate matters before they get into court. So we encourage the person that's been paying for everything to continue to do that. Otherwise, so we talk about maintaining the status quo. We want to make sure that we're not running into court when we don't need to be. We want to try and negotiate in a reasonable fashion, and simply cutting somebody off isn't going to achieve that.
So do you tell them, do you give a client advice on how to break up, how to break the news? Or do you just send a letter to the person saying, I've been retained to tell you that you're now separated?
I try to avoid that. I mean, that's a very personal conversation. We try to deal with the legal side of things and leave the more emotional side. I mean, there is some intersection, obviously, but we try to encourage the client to come to us when they're ready or when they have already had that conversation with their spouse.
And is there something they need to do with their property before they tell their spouse that they're going to leave them?
No, not really. I mean, to the extent
Except
that
not hide it.
Not hide it, not try and transfer it into somebody else's name, maintaining the, paying the bills, doing that kind of thing, particularly where it's a jointly held property. So if you've got a house that both parties own, and one of them just stops paying the bills, the person that has the money that stops paying the bills, there's a practical problem for them because they're going to have a bank knocking on their door. It's going to affect their credit rating. So beyond just the family law issues, they're going to have some practical concerns about this.
Well, let me ask you a question that I hear all the time, and that is, there's a myth out there that if you move out, you've somehow given up some rights.
Right. Well,
and there are these couples that I see in court who stayed together under the same roof for years because neither one would move out.
Right.
Because they thought that if they moved out, they'd lose something.
Well, if you own the property jointly, then you still have ownership rights of the property. So it doesn't. If you don't, it will depend if you're married or not. There's a little bit of a difference between married spouses and non-married spouses. But typically, you preserve or you keep your rights, even if you do move out. There may be a bit of a distinction when you're talking about children, and while you still have legal rights, it may change the way that it's your involvement in children's issues would be perceived. So if you move out and leave childcare responsibilities to the spouse that stays in the home, it would be then sort of difficult to say, oh, well, I've been the primary parent since separation.
And what if the person says to you, I want to move out, but I want to take my kids with me?
The hope is that you can negotiate some kind of an arrangement so that both parents feel secure in having them move out, because if there are safety concerns, if there's been violence in the home, those are some very serious issues, and you don't want to encourage people to stay, and you have to weigh in each case what's going to be more important, whether or not there's again, safety and violence concerns and children being impacted by that.
So obviously safety comes first. If a person needs to protect themselves and their children and move out, you would tell them what they need to do about that. You might go to court and get a restraining order. But let's say there isn't a violent situation. There's just a person that says, I believe I'm the better parent. I'm the primary caregiver. I want to move out. I want to take my children with me. How do you as a lawyer make that determination to advise them about whether to do that when the other spouse has no clue? Because I got to tell you, I see cases in court all the time where a mother or a father says that they came home from work, they found the place empty, children are gone, they have no idea where they are. It happens all the time in family court.
I mean, we don't encourage clients to take steps like that without telling the other parent where they're going to be, where the children are going to be. First of all, it's really traumatic for kids. So, you don't want to encourage people to do things that are going to be traumatic for their children and ultimately undermine their position.
So is there a way, do you think, to break up if you do it in a civilized way and without cheating or betraying the other person and hurting them unnecessarily? Can it be a little easier than if you try to take self-help measures on your own?
Right, absolutely. And I think that people can really assist themselves in dealing with the process by, first of all, being proactive about it, coming to see a lawyer, figuring out sort of an orderly way of dealing with a breakdown of a relationship, which is going to be difficult for everybody, and not doing the extreme self-help sort of thing. So there are lots of ways that clients can help themselves.
Well, Erin, I want to thank you so much for being on the show. I think you've given us a lot of very helpful information, and I hope people watching who are in this situation will take your words to heart. Thank you.
Thank you so much.
When it's hard to meet or even talk together, Put the power of computer software and trained negotiators to work for you. Lawyers, mediators, and families can harness Smart Settle software to produce high-value agreements for separation, estate, and elder care. Smart Settle software can help parties reach an agreement worth 10 to 20% more value for everyone. Get connected, get smart, get settled. Learn more right now at smartsettlefamily.com. It can be difficult to talk with family about estate planning at the best of times. Many families don't talk enough about the issues they face, such as remarriage or the family business.
Hi, I'm Jim Doyle. I help navigate the complexities of today's modern family when it comes to integrating your investment and legacy planning needs. Wouldn't it be nice to see your professional advisors speaking to you with a common voice?
When protecting your legacy is important, ask how Jim Doyle and Investors Group can help.
I'm Lorne MacLean. Today on Q&A, our question is, my spouse and I want to separate, but don't think we can afford it. Help! The most stressful thing about family separation is that there is often not enough money to go around. Past arrangements that worked when the couple was together quickly become financially impossible. Paying for a spouse to retrain and re-educate pays off for both spouses and their children, even after paying for daycare. Sharing child custody shares the burden of raising children and can also result in some big tax savings and improved cash flow for both separated spouses. It allows for a higher amount of deductible spousal support, better direct deductions for daycare costs, and a lower payment of non-deductible child support. Pay your debts off rapidly by paying more tax-deductible spousal support to a lower income-earning spouse and have them use the support money to pay off half or more of the family debt. Smart separating couples take advantage of tax planning to decrease the cost of separation, and you should too.
Thanks for watching. For extended interviews and exclusive content, please visit our website at familymatterstv.com. If you'd like to submit your legal question to our Q&A, go to advicescene.com. I'm Justice Harvey Brownstone. See you next time.